All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case in the docket scheduled for oral argument this morning, the case of Shazette Davis versus Big Bend Hospice, Inc. Counsel, are you ready to proceed? You may approach. Counsel, we've allocated 20 minutes per side for the oral argument this morning. Would you like to reserve some time for rebuttal?
Yes, sir. I'd like to reserve 5 minutes with the court's approval.
So noted, Madam Clerk. You may continue, counsel.
May it please the court? My name is Ashley Richardson, and I represent Ms. Davis in the appeal that's presently before you. The issue before the court is actually a very, very narrow one, but one with wide-ranging implications for employees across the state of Florida, and that is the applicable statute of limitations for claims brought pursuant to the Florida Civil Rights Act, where the Florida Commission on Human Relations takes no action on a claimant's charge of discrimination within the prescribed 180-day period. Prior to 2023, that decision was already made. The Supreme Court, in its case in Joshua in 2000, longer ago than I was realizing, the Supreme Court in Joshua answered that question directly in big letters. They agreed that where the FCHR fails to take any action within 180 days, the plaintiff's claim is subject to the 4-year statute of limitations found in Chapter 95. Arguing that under section 760.11 sub 8, which covers this particular topic and says that where the FCHR takes no action, a claimant may proceed as if they were reasonable cause had been determined, was not necessarily determinative, didn't prescribe the 1-year statute of limitations. 4 years had to apply to preserve a claimant's right of access to court. Otherwise, we would be waiting sort of indefinitely for the FCHR to take some kind of action. That case law stood for 23 years until the fourth case.
The argues that Joshua is distinguishable from the facts of this case.
So the distinguishment or the argument that the Alou court in the Fourth CCA made was that in Joshua there was no corresponding EEOC charge or notice from the EEOC, whereas here there actually was notice received by Ms. Davis from the EEOC only. But that distinction doesn't change the analysis of Joshua, because if you look at the 2020 amendments that the legislature just made to subsection 8, it actually supports the holding in Joshua, where the EEOC, the FCHR, they're not the same entity. Their notices, and this is following Woodham, the 2001 case that followed Joshua, notice from the EEOC and notice from the FCHR are not legally the same thing. They don't notify a claimant of their rights under each statute. So if we look at the EEOC notice of right to sue that was issued to Ms. Davis, and it's a standard form, was issued to Ms. Davis in 2021, that form says that she has 90 days to bring federal claims under Title VII. It is completely silent as to what she may do under state law claims, because, for example, some states don't even have their own Civil Rights Act, so they're only proceeding under these federal statutes. In Florida, obviously, we have our own Civil Rights Act. It comes with its own set of deadlines, its own set of investigations, its own set of rules, different damages. The statutes are fundamentally different from one another as they arise from different sovereigns. So
aren't there, these federal trial court decisions that say that the deadlines imposed by the EEOC, the notices that are given, do in fact apply to FCHR deadlines? I think I remember seeing that. I think even the trial court in this case cited one federal court order, and I know in Hines there were a couple of them.
The ones in Hines were distinguished by the first DCA.
Yeah, but it does say that.
Right, it does. But if we look at the one federal decision, the Southern District, I think you're referring to as the Millen or Millian decision, that one just follows Alou. If we look to the Northern District, we have Marbury, Ruffin, there's several others, Strachan, that the Northern District and several judges, Weatherall, Hinkle, a couple of them have come to this conclusion that the notices following the Woodham decision are not the same. And if we look at subsection, it's 760.11.8b under the new statutory scheme, that notice from the FCHR has to be very, very specific. First, it has to come from the commission, which is defined by Chapter 760 as the FCHR, not the EEOC. It has to inform the claimant what their rights are under Florida law, and it has to inform them that from the date that notice is mailed, they have 1 year to bring suit. That did not happen in this case. The notice she received from the EEOC is utterly silent as to those particular topics.
So your interpretation of the 2020 amendment is that if FCHR continues to do absolutely nothing, then Joshua still applies?
Correct.
Okay.
And if you look at the plain language of the statute, so the 2019 version of sub 8 is now just sub 8A. They added B and C, but they didn't actually change any of the language of what used to be just subsection 8. So if you look at the language of subsection B, it says that the commission shall promptly notify the aggrieved party. That didn't happen here. Subsection B doesn't apply. The notice from the EEOC was not issued by the Florida Commission. It did not contain any of the information required by subsection 4, doesn't tell them that they have to file an action within 1 year.
Is it possible that the FCHR isn't notifying the claimants because they are relying on the EEOC when they've dual filed? That
So-
seems to have been my impression.
It does, but at the same time, Joshua is now 24 years old and took into consideration the fact that the FCHR was not notifying people within that 180 days. In the 24 years, nothing has changed either statutorily or based on case law, other than the ALU decision, that would change that structure in any way, shape, or form. Like, the FCHR could issue a notice, and according to subsection B, they're supposed to, but they don't. And when they don't, subsection B doesn't apply.
But when Joshua came out, there wasn't a requirement that the commission do anything expressly.
I mean, and to be fair, it says that the commission shall, but when the commission doesn't, subsection B can't apply because they haven't taken the action that's required by statute.
Well, isn't another way to look at it that your client is depending on the commission actually doing something? You can't do something until they do something. They haven't done that thing. You're relying on them to do something so that you can do something. Why wouldn't that obligate you to then seek mandamus against the commission to issue what the statute requires them to issue?
Well, I think that was what Joshua was attempting to close up that loophole, was what happens? Do we just sit here in limbo forever, waiting on the SHR?
But there wasn't a statute that required the commission to do anything, and now there is.
Well, I mean, the entire statutory scheme that created the FCHR was designed to get them to do something and push this administrative process through. The legislature, I mean, to the extent they may have wanted to close that loophole, didn't, based on this language. They could have very easily included a subsection D for when the FCHR doesn't do anything. Like, let's say that they don't get it done within 180 days. We're understaffed. There's budget issues. Things happen. They chose not to include that language despite Joshua existing for 2 decades at the time those amendments were enacted.
Do you think that your client has a clear legal right to have the commission issue something, like telling you, okay, we're not doing anything, or you don't have a right to sue, or that you do have a right to sue?
I mean, I would argue that under the statute, it would be very nice if they would issue any kind of, determination, but whether or not she's statutorily obligated in any way to get that paperwork, I mean, it's not happening. So we're sort of stuck in a situation where we have to proceed forward, and she needs to be able to get access to court.
Well, what would happen if the commission were watching this OA right now and they decided to issue a notice tomorrow?
It's outside the 180 days. Subsection B says that, subsection 8, the initial opening says that they have to take action within 180 days.
Right.
So if they don't,
But the
subsection.
notice doesn't have to be issued within 180 days.
Well, no, they have to notify, they have to conciliate or determine whether there's reasonable cause within 180 days. And if they don't, I mean, the notice is the only way we have any indication that they've done anything.
Are you saying the statute requires that the notice also be issued within 180 days?
It's, I mean, from the plain reading of it, yes, that it needs to be issued within 180 days. Otherwise, we're just sitting out here in, because if it's issued on day 200, that's not within 180 days. And as of day 181, the client can proceed to court having fully exhausted their administrative remedies. The whole purpose of the Florida Civil Rights Act and the administrative process is to ensure that we've vetted these claims prior to them going to court. If the FCHR doesn't do anything, how long is the claimant supposed to wait? Joshua answered that and said, you got 4 years.
Well, but it says 8 says 180 days if the commission fails to conciliate or determine whether there's reasonable cause. Then you can proceed under subsection 4. B says the commission shall promptly notify the person of this failure. and doesn't doesn't give a time period.
No, it doesn't, and that's actually one of the issues that we have, and that was one of the things that Joshua sought to remedy, that the legislature still hasn't corrected.
Well, Joshua couldn't seek to remedy it because the statute didn't exist at the time Joshua came out.
Not that portion of it, but the 180 days, that language from the opening section of 8 was in existence at the time that Joshua was issued. The problem is, if we don't have that 180 days, when does that clock begin to tick? If we're waiting for some kind of notice to be issued outside of that prescribed 180 days, we're just stuck in limbo indefinitely.
Well, a year runs from when you get the notice, or when it's certified that notice was sent.
But if there's no notice, that's the issue we have in this case. There's no dispute that she didn't receive any
Your
notice.
client is sitting in limbo, waiting for the commission to do something that it's obligated to do by statute. So why shouldn't your client be required to do something to get the commission to do what it's supposed to do?
Because Chapter 760 is to be liberally interpreted in favor of the employee's rights. So forcing them to then go an additional step and request that the commission do its job in a timely fashion is outside the scope of what the employee is required or obligated to do. And there's no case, at least as far as I'm aware of, that suggests that the employee now bears the burden of having completed their administrative requirements, which is to file a charge with the commission, that they are now required to do even more work to guarantee their right of access to court. The
That's
commission.
not-
But the
Go
sta-
ahead.
the- I'm sorry.
Go ahead.
I'll stop. Go ahead. No?
Does the work sharing agreement have any bearing on this case?
I would say no, and that's following Woodham. So the work-sharing agreement allows the agencies to avoid duplicative investigations and the wasting of resources, but the statutory schemes are fundamentally different. We have a federal and we have a state. And Woodham is at least instructive in this instance because it states that a reasonable cause determination a notice of rights and dismissal from one agency is not a reasonable cause determination from the other agency. They have completely different rules and statutory setups, and while they might share investigatory powers, they don't, none of the other statutory provisions are conflated. That would be like if we were going to assume that the EEOC filing deadline now applies to the state court claims, even though they're different based on the statutes. So I would say that no, the work-sharing agreement in no way supports a finding that the EEOC notice complies with the subsection 8B, because it just flat doesn't. The definition of the commission in the Chapter 760 is just the FCHR. It doesn't say, and sometimes the EEOC or both commissions, it says the FCHR. And that is who is supposed to issue some kind of notice to a claimant who has filed a charge with them. They didn't in this case. It's unfortunate and it causes us a lot of problems, but that is where we are at, and that is why
Why does it cause you
Joshua.
a lot of problems? It buys you 3 extra years.
Well, it buys you 3 extra years if Joshua governs. If Olu doesn't, then my client has now been foreclosed from going to court a full 6 months afterwards. So her notice from the EEOC, which we argue is not in compliance or in any way qualified under Section 8B, that was issued 6 months before Olu. Her 1 year would have expired 6 months before Olu. It was 18 months prior to that decision that she got the EEOC notice. So just on the issue of fundamental fairness in her access to court, anyone who's stuck in this weird pre-Olu limbo has been denied the opportunity to go to court based on a case that changed the landscape without any indication that that was going to happen. It basically upended Joshua arbitrarily. It just changed the review of things and said, oh, well, because she also dual filed with the EEOC, that notice is sufficient, but it's not. And based on what the words that the legislature wrote, that notice is not sufficient. They
But
didn't.
your reading then puts in the hands of the commission through inertia, gives every claimant an extra 3 years.
Only the ones that it doesn't notify.
That's what I
within.
mean. What I mean is, if the commission does nothing, if it fails to comply with the requirement in 8B, and let's say the commission just decides as a matter of informal policy, we're not going to send notices. Because they know that means that then every claimant has an extra 3 years to file their complaint.
Right, and that is
How does that work with the statute, as opposed to a middle road reading of the statute, which is you can't act until the commission acts, and it puts it in your hands to get the commission to do something so that you can proceed under the statute?
There's no statutory or case law precedent that would put that burden on the employee. There's decades of case law that say that this is to be liberally construed
Well,
in
what is the
favor.
purpose of the notice? What is the purpose of this notice?
The purpose of this notice is to inform the client of their rights. you've
Your
laid.
client has been represented by your firm since the very beginning.
They
Does
have,
your
but
firm
not all-
know what her rights are?
I know, I would agree, and hopefully you have an attorney that can help you through that process, but a lot of people go through the administrative process pro se. Like, I've represented a number of them who have come through the administrative process and didn't contact us until they got that EEOC thing that said, oh, you have X amount of time to go to court, and it's like, court is scary, let me find an attorney. Not everybody is going to go through that administrative process with a qualified attorney helping them out. So if you're just waiting on this notice and it never comes, we're now asking essentially a group of non-lawyer aggrieved employees to figure out that they have to then contact the commission, request a piece of paper from them so that they can start the 1-year clock in order to go to court. That's not how the statute is written. That's not how it's designed.
Well, why isn't there an expectation of some agency on behalf of the complainant to, if they are required to file something with the commission before they can sue, 180 days has come and gone, they haven't heard anything from the commission, you're saying there's no responsibility to contact the commission and ask this agency to do its job?
Respectfully, it's the agency's job to do its job. There's no indication in either statute or the last 24 years of case law since Joshua that the claimant is supposed to be the one doing the job for the agency. They have the obligation and are required to exhaust their administrative remedies by filing a charge of discrimination. If the if the FCHR doesn't do its job within 180 days, then we default to Joshua. The 4-year statute of limitations applies. The legislature had the opportunity to fix this problem for all of us and include language that says, if the FCHR doesn't do anything within 180 days, then your 1-year clock starts on day 181. They didn't put that in here. They didn't change the definition of commission to include notice from the EEOC. They made no substantive changes that would have in any way upended Joshua. So we're still here with Joshua applying. That notice from the EEOC did not trigger any kind of deadline because it was not issued by the FCHR. It doesn't tell you what your rights are under Florida law or that you have 1 year to bring suit from the date that notice was mailed.
Counsel, assume for the sake of argument that we agree with your arguments, then would we have to declare a conflict with Alou?
Yes. Yes, you would.
You're into your rebuttal time.
Yes, thank you.
You may proceed, counsel.
Good morning, Your Honors. May it please the Court, Reynaldo Velasquez Jackson Lewis on behalf of Big Bend Hospice. I'm going to start on some of the issues that this Court has raised that I believe is very significant. And I think the first issue that's important to discuss is we're not here to blame what the legislature did or didn't do, and we're not necessarily here to blame what the Florida Commission on Human Relations did or didn't do. This is what we have from a factual perspective. We have what we have. We have the statute. The Court now has to interpret that statute based on the facts that it has before us. And the facts that we have in the decision that Alou reached on the basis of Woodham makes sense. And it's practical and it is consistent with the statutory scheme.
Please explain how Woodham supports your argument.
Certainly, Your Honor. So when you look at Woodham, it basically has this factual pattern. In the plaintiff and Woodham dual filed their discrimination charge with the EEOC, which is the exact same thing that happened in this case. The plaintiff and Woodham received a dismissal and notice of rights, which is the same thing that happened in this case. The FCHR in the Woodham case never made a cause or no cause determination, which is the same thing that happened in this case, Your Honor. And with that factual pattern, the Woodham court concluded that in such a situation, the plaintiff could proceed under Section 7611, subparagraph 4, as opposed to being foreclosed into an administrative remedy under subsection 3. So basically what Woodham did is take the factual pattern that we have right now in a slightly different case, but in consistency in the 3 points that I mentioned, and said that the plaintiff in that case could go through Section 7611, subparagraph 4. And that's key for numerous reasons. What Woodham said in that particular scenario is a situation where the EEOC was handling the case, and the EEOC issued the notice of determination. In the court, the Supreme Court in that case said, based on the EEOC's determination, they can apply the Florida Civil Rights Act and go through that particular mechanism. And going back to.
Did they weigh in Woodham, excuse me, on whether Woodham was subject to the one-year statute of limitations, or whether they got 4 years because FCHR never acted?
They did not, Your Honor, because that wasn't the issue that the court was dealing with.
But can it simply be harmonized with Joshua in that respect? In other words, it could have been it's not inconsistent with the idea that you still would have 4 years to bring an action under 760.11 sub 4.
In the way that Woodham is written, it could be open to that interpretation, Your Honor, but that isn't the logical way to apply Woodham. And we think, and we respectfully submit to this court, that Alou is the way to properly interpret Woodham. And we'll take the facts in Alou and see how they are analogous to Woodham and our cases, Your Honor. So in Alou, the court affirmed a circuit court order granting summary judgment to the defendant because they filed their case a year after the EEOC had issued its notice of determination. And here are the facts. The plaintiff in Alou dual filed with the EEOC and the FCHR. Same thing that we have. And Woodham, same thing that we have in this case, Your Honor. The second thing is the FCHR never made a no cause or cause determination. Same thing we have in Woodham, same thing we have in this case, Your Honors. The third point is the EEOC issued a dismissal and notice of rights. Same thing we have in Woodham, same thing we have in this case. The fourth issue is, same thing in Alou now and here. The plaintiff filed their lawsuit 1 year after the EEOC issued its notice of rights. And in that case, Alou took that Woodham analysis that is consistent all the way through, with the exception of the ultimate issue, and says when you apply Alou's factual pattern where it says that the plaintiff is free to go through 760, 11 subparagraph 4, and you apply it here, well then the plaintiff here is also free to do so as well. And in this case, in this situation, the notice from the EEOC stands in the stead of what the FCHR has failed to do.
And what is the statutory basis for that statement? Like, where in the statute does it allow, the commission is defined very specifically to include only the Commission on Human Relations,
So-
and not EEOC. Do you agree with that?
You're correct, Judge
And
Hanaway.
you agree that the word commission, a defined term, is the only reference in 8B, in 8A, as something that has to happen. It's to be done by the commission, as already been defined. So where do you get the substitution principle?
So that is built from the court's interpretation from the statute. And one case that
Which
did
court's
exactly that.
interpretation?
Yes, Your Honor.
Which court's interpretation?
So this was a Southern District Court of Florida, the Milan case.
And why do I care what a U.S. district judge has to say about Florida law?
Just from a persuasiveness, Your Honor, perspective, and to submit the argument. In that case, the Milan court reasoned that in a scenario where the statute allows for dual filing and provides for dual filing, right? That it follows logically that if you're going to allow a plaintiff to or a charging party to file a charge with the Florida Commission on Human Relations and the Equal Employment Opportunity Commission and the EEOC, to Judge Lewis's point, work sharing agreement has a responsibility to investigate that, then the only logical and reasonable conclusion, Judge Tannenbaum, is that the EEOC is in fact applying the Florida Civil Rights Act and those particular provisions.
But that actually appears nowhere in the federal regulations, and it's actually the opposite appearing in the federal regulations and in Title VII. It's the opposite of that. The EEOC enforces federal law and federal law alone. The EEOC is responsible for investigating only federal violations. And the notice, Form 5, expressly says that this is only pursuant to federal law. So I don't understand what follows from that, other than the filing with the EEOC is the equivalent of filing with the Florida Commission. And in fact, the regulations say that when the EEOC receives a complaint, it's going to send it to, and this is actually in the work sharing agreement as well, that complaint goes to the commission. which means that the commission has that complaint and is free to do something if it chooses to do it. And then the commission, when it does its, the EEOC does its thing, presumably should notify the commission, or the commission will find out what the EEOC did so that it can act as required under Florida statute. That is a reasonable reading of everything together. Why do we have, with all that, in light of all of that, how is it that we have to jump ahead and say, well, commission just means EEOC as well? Because we can't imagine another, a universe where that can coexist.
Because, Your Honor, if we don't, either I or another defense attorney is going to be before this court saying that the FCHR never issued a notice. 10 years down the road, they decide to sue their employer, and they'll come in there and argue, well, a notice was never issued. So the statute of limitations started running. So we don't have a 1-year limitation. We don't have a 4-year limitation. We don't have anything because the FCHR didn't do anything. And that's not what the Florida Commission or what the Florida Civil Rights Act contemplates.
Well, on the flip side, though, why can't it be that Ms. Davis doesn't have a right of action yet because the commission hasn't acted?
That
And
could-
no statutes have started running, and there's no right to sue yet.
So, Your Honor, that is a viable option from a perspective of an argument, but the fact of the
Is
matter...
it inconsistent with the statute, what I just asked? Does that reading conflict with how the statute reads?
I believe it does, Your Honor, because the statute says that after 180 days, the plaintiff or the charging party can proceed under Section 760.11, subparagraph 4. So when the commission doesn't act, the
But you
charging
don't know
party...
that the commission hasn't
But-
acted. It says that if the commission has failed to reconcile or does something else.
And if they fail to, if they fail to find cause or no cause, then they have in essence failed to act with respect to that specific responsibility.
But the claimant doesn't know that yet, because the commission is then required to notify the claimant that that event has happened.
But that's where the EEOC's notice of rights steps in, as Alou pointed out.
But the EEOC can't speak for the commission. The commission is specifically charged under the statute to do something, to investigate and make determinations, reconcile, all those kinds of things. I have a different question, but I will pause and let my colleagues ask questions.
So I proceed, but yes, Judge.
Going back to Judge Tannenbaum's point, that the commission is specifically defined in 760 as FCHR, and the commission is used throughout Chapter 760. If we accept your interpretation, then wouldn't we be reading additional words into the statute?
Respectfully, Your Honor, but I would say no. I would say
Why
that-
not?
I would say because, unfortunately, because of the manner in which the statute is written, it's left to the courts to interpret those statutes. And there's one sister court, the 4th DCA, that has interpreted that statute in a manner in which is consistent with the position for Big Ben Hospice here. And that is that a notice of rights under the EEOC is parallel and does in fact trigger the 1-year period as it relates to the Florida Commission or the Florida Civil Rights Act. And from that perspective, I think it's very important to note that if there isn't a triggering event, then, as I mentioned in response to Judge Tannenbaum's question, this goes on indefinitely. We could wind up seeing situations where 8-9 years down the road, there's somebody filing a suit and they say nothing ever happened. So the 4th DCA in that case construed the facts that it had, applied it to the law, and came out with what is a sound and reasoned opinion. And we respectfully submit to the court that what the 4th DCA did is more on point with respect to the particular facts of this case than it is in Joshua. As I believe it was Judge Lewis pointed out, in Joshua, there's two differences. One is the fact that there was never a determination by the EEOC in that case. So that there was complete silence, and that facilitated the 4-year statute of limitations for the plaintiff in this case. Here, the plaintiff did get notice. They did get notice from the EEOC, and that notice, logically, from an interpretation of all the statutes, which I believe Alou also mentioned, reaches the conclusion that that act by the EEOC is what triggers the starting point from the perspective of the time frame. And I
Well,
think it's,
interpretation of all the statutes except for the definition of commission. That's the one statute that the Fourth ECA chose to not consider in its consideration of interpretation.
that's correct, Your Honor,
Right.
but
So what is it, so is that basically an absurdity doctrine type of argument? Like, well, we just can't imagine how this is all going to work together, except if we read the legislature's definition into a nullity. Like, thank you, legislature, we'll take it from here, we know better as to how to run this chapter than you do, so we'll just read it the way that makes sense to us. Is that the proper statutory construction?
I would say no, respectfully, Your Honor, but I would also say that we're talking a lot about what the Florida Civil Rights Act does say, and it's also, I think, important to know what it doesn't say, and there's nothing in the Florida Civil Rights Act that says that the one-year filing deadline at issue begins to run only after the notice referenced in Section 76011, subparagraph 8B is issued. It doesn't say that. There's nowhere, if we're going to talk about what the Florida Civil Rights Act does say and doesn't say, the Act doesn't say that. So if it doesn't say that, the unfortunate reality of it, based on the case that we have here, is that the legislature has left it to the courts to interpret the statute and make a determination in its infinite wisdom as to what is the appropriate mechanism. And we respectfully submit that in a situation like this, where the statute is silenced, that statute, that limitation period, that one-year limitation period has to start at some point in time. And when the FCHR defers to the EEOC and does nothing on a claim, and the EEOC issues a notice of rights and a determination, that is the triggering event. Because if not, we wind up in the vicious cycle that I was suggesting, then it never starts.
Can a Florida agency, without statutory authorization, delegate its duty to another agency? Or to an outside party, a third party? Without statutory authorization, can an agency that's been tasked with some responsibility, some action, can it delegate that to an outside party?
I did not look at that, Judge Tannenbaum, but I will say this, as all of you know, there is a work-sharing agreement where the FCHR has effectively done that in certain circumstances.
Well,
And-
right, but my question is there's, unless you can point me to something, I don't think there's statutory authorization to do that, is there? Or is,
I wouldn't be able to tell you one way or the other, Judge Tannenbaum. Unfortunately, I did not look at that specific issue. But I'm not aware of any. But in this particular case, what we do know is that there is a work-sharing agreement, and the Florida Commission on Human Relations utilizes that.
Right, and that work-sharing agreement essentially allows the EEOC to do the sort of the back work for the commission. So, sort of the legwork and do the investigation and all that kind of stuff. Maybe there's a report that's produced or something like that. But the statute itself, the Florida statute, still tasks the commission at the end of the day with taking official action on that in some way or another. And I'm not aware of any authority where an agency can delegate official action to a federal agency, but at least without statutory authorization.
Yeah, in this, I'm not aware.
But that's what you're arguing. You're basically arguing, and Alou has argued, basically, as part of his analysis, that in fact can happen. That we don't really care what the definition of commission is, which the legislature was very specific about it, and we don't care. Like, they were basically the same. I mean, commission's in both names of the agency, so it's close enough. But even Form 5 discounts or disclaims that that it's operative under Florida law in any way. So I'm still not following how we can read a statute to mean what it doesn't say.
I think the situation we're in is that we're interpreting by construction. It is a problem. And unfortunately, that's a problem that winds up falling on the hands of us as counsel and as the court to interpret the statute based on the law and the facts that it has before it and reach some type of a conclusion.
You mentioned construe the statute as constructed. In Joshua, the Supreme Court said, we are guided by the legislature's stated purpose for enacting this chapter, that's 760, and its directive that the act be liberally construed in reaching our decision. Wouldn't a liberal construction of the statute be consistent with the appellant's argument? If not, why not?
A liberal construction would essentially completely undercut the whole intent of the Florida Civil Rights Act and public policy, because I think it goes back to, well, let me take a step back. We don't believe that our interpretation is not a liberal interpretation. Now, but everything has its limits, Your Honors. And to the point that there isn't a limit here, and the statute is construed in such a fashion where the FCHR is permitted to do nothing, and charging parties are allowed to say that, well, then the 1-year statute of limitation never started running, and that means I'm free to file a lawsuit a year and a half, 2 years, 3 years, 5 years, 6 years. That would run against the express language of what the Florida Civil Rights is saying, and that is you have 1 year to act when the Florida Commission on Human Relations does not take action.
That's not what the statute says.
Pardon me?
That's not what the statute says. The statute says you have 1 year to act after the commission does something, after the commission sends you notice.
Well, respectfully, Your Honor, the statute says that if the commission does not issue a cause or no cause determination within 180 days, then the charging party is free to act.
But they have to act within a year of certification from the commission that it sent notice.
Well, and that's the question, right, Your Honor? And what we're respectfully submitting to the court here is if the FCHR is silent as to when that 1 year period starts, which it is, the Florida Civil Rights Act does not say when that 1 year period starts.
And when does it start?
We submit to the court, Your Honor, that in the manner in which Alou analyzed it, Judge Lewis, and that is it starts when the EEOC issues its notice of rights, and the plaintiff at that time has notification that its charge is over, and they have 1 year to act from that moment moving forward.
Which is actually the one thing that is not in the statute. So I don't understand how, of all the constructions possible, the one that you're going on is the one that is not in the text of the statute. The statute expressly says it's 1 year from the date that the commission certifies. The commission's been defined, and it's not the EEOC. So instead of this Herculean exercise in reading stuff into the statute that's not there, isn't a better reading that the 1 year runs from when the notice is certified from the commission, and because it doesn't start running, that means that she doesn't have a right to sue until the commission finishes doing what it's supposed to do.
That would be a viable option, Your Honor, but that still doesn't stop them, the charging party, in this case the plaintiff, from going ahead and filing a lawsuit, and then we wind up in this type of litigation, whether it's on the basis that we're arguing here or the basis that yourself have contemplated. And I'll close with this, Judge Tannenbaum. Whether you judge the 1 year mark from the moment where the notice of dismissal was issued in this case, or whether you judge the 1 year from the moment that the FCHR, the 180 days passed and the FCHR did not issue a cause or no cause determination, the filing in this case was outside of a year in both instances. Thank you for your time, Your Honors. Yes, sir, Judge.
I'm quoting from the Supreme Court's opinion in Woodham. It says, finally, if the FCHR fails within 180 days to make a determination either way regarding whether reasonable cause exists, Section 760.11.8 states that the claimant may proceed under subsection 4 as if FCHR made a reasonable cause determination.
Yes, Your Honor. And that's exactly what Alou relied on for purposes of building for its decision by analogy with respect to if, in that case, the Supreme Court ruled that when there isn't an action, they can proceed under 760.11.4. In this case, in Alou's case, they were able to do so as well. And in this case, they were able to do so as well, but they failed to do it in a 1 year time period.
And when does the clock start to run?
So we would respectfully submit that the clock starts running, Judge Lewis, when the EEOC issues its notice. But even if we take a more liberal approach here and we say that maybe the more appropriate way is for the clock to start running on the 180th day of the FCHR not acting, well, if you judge that in this case under the facts, these are the facts as it relates to that particular issue, Your Honor. You have December 9th, 2020, the charge is dual filed. On June 21 of 2021, 180 days from the filing of the charge passed. On June 20 of 2022 would have been the 1-year mark for the charging party to file a lawsuit within 1 year of the commission failing to act. And in this case, they filed the lawsuit on December 8th, which was 1 year outside of the EEOC notice and 1 year outside of a more liberal reading that the statute, the 1-year period runs when the FCHR failed to act.
Why would they not get the 4-year statute as set forth in Joshua to file a lawsuit under Chapter 95?
Pardon me, Your Honor.
Why wouldn't the plaintiff get the 4 years to file a lawsuit under Joshua?
So it's our position, Your Honor, that the construction of the statute doesn't afford that. And as Joshua pointed out, that was a situation where nothing happened from the perspective of the FCHR or the EEOC. There was complete silence on both fronts, and in this instance, there isn't.
Thank you.
Respectfully, thank you, Your Honors.
Read my notes. I'd like to start with the dates that were just referenced, since they're sort of fresh in the court's mind. One of the fundamental issues here is going to be that issue of retroactive applicability. So for the 1-year statute of limitations to apply based on a lieu, our client would quite literally have to time travel in order to go back and perfect her claim and bring it timely before the trial court, because the case that was in effect at the time, Joshua, said that the 4-year statute of limitations applied. A lieu was issued in 2023, well after that 1-year period would have expired. So just for Ms. Davis's purpose alone, she lost her right of access to court, which directly contravenes the liberal construction of Chapter 760, and basically gave her no chance to be able to apply the 1-year statute of limitations because she didn't know it was coming. Joshua was the law of the land until a lieu came along and confused everything. There was also some discussion about the Woodham decision, and it's our position and several other judges' positions that a lieu wildly misconstrued this case. Judge Wetherell in Ruffin, I think, said it best when he said that a lieu found that Woodham was controlling, but the issue decided by the Florida Supreme Court in that case was not whether the EEOC right to sue letter could trigger the 1-year statute of limitations under sub 5. Rather, the only issue decided in Woodham was that the EEOC right to sue letter was not equivalent to a no-cause determination by the FCHR for the purpose of triggering the 35-day DOA appeal period. So Woodham says exactly what we're saying, which is that the notice received from the EEOC is not the notice that's required under 8B to be issued by the Florida Commission. So if anything,
Well, it certainly suggests that the EEOC notice has some sort of relevance to 760.11. Granted, it's not exactly what it says here, but it did say that one part of 760.11 did not apply because there was an EEOC determination. So why can't we say that, well, the Supreme Court has said that there is some relevance to an EEOC determination, said so in Woodham.
right, because the language of subsection 8 or 8B says that that notice has to be issued by the commission, and it has to contain information about your state law claims and rights, including that a 1-year statute.
So does that statute overrule Woodham?
It's not that, I don't think that it overrules it. I think it runs in tandem with it. Woodham says that the notices are not, you can't really cross-apply the notice for purposes of triggering that DOA investigation, where the FCHR to issue a no-cause finding, you have to proceed to DOA. There's a totally separate provision that's obviously not at issue here. And the Woodham decision says that whatever the EEOC says, that's not the same as a no-cause determination from the FCHR. That logic still applies under 8B, because 8B specifically says that the commission, the FCHR, has to issue a notice with specific information included in it. That is, there is no dispute that that information is not contained in the EEOC's notice of dismissal.
But you do agree that EEOC can issue a notice that complies with subsection 3?
I think that it's a possibility, but it doesn't currently exist. That form that comes from the EEOC has had standard language for like 2 decades, and it doesn't include anything about the specific state statutes. My assumption would be because there's 50 different states with 50 different statutory schemes, and it's not covering all of them, nor is the federal government required to sort of inform you of what your Florida rights
And I
are.
assume for the sake of argument that the notice did comply, does comply with subsection 3. How long would plaintiff have to file the lawsuit?
You mean if it's complied with subsection 8 and included all of that information? If there was some kind of, I still don't think that that would work, because the statutory scheme as drafted and amended in 2020 defines the commission as the FCHR. So even if the EEOC included all of that additional language, we still have the issue that it wasn't, the notice wasn't sent by the FCHR. The FCHR cannot certify the date that it sent the notice to trigger the 1U statute because it didn't send the notice. So really, we're just looking at the basic language of the statute. It doesn't include that depth of information. And this was brought up several times during my colleague's argument, that the statutory scheme as written is completely silent, unfortunately, on the situation we find ourselves in. It's assuming, for goodwill purposes, that the FCHR will do its job in a timely fashion, and it doesn't contain any information about what happens when the FCHR doesn't do its job on time. Joshua solved that problem.
Don't you, the Florida Supreme Court, generally speaking, has been clear that there are a couple components to a statute of limitations question. One of them, maybe the most important one, is when does the action accrue? Like, when is your right of action or your cause of action accrue? Doesn't 760.11 sub 4 provide that accrual? Like, when the commission has made a determination one way or the other, that's your accrual, that's when you have a right to sue.
And
Do you agree with that?
I do to an extent, but Joshua explains the distinction with the way that sub 8 was previously drafted, and that language has remained unchanged in the subsection A, the way they've broken it apart, is that, and the legislature didn't change this word, it says that a claimant may proceed as if reasonable cause was found under subsection 4, but it doesn't say shall. It's permissive, not mandatory, which is why Joshua said that in order to preserve those due process rights, which is something this court has agreed with in the Hines decision in 2019, was that to preserve that right of access to court and a claimant's due process rights, we have to apply the 4-year statute of limitations, because the legislature did not require a claimant to proceed under subsection 4. It gave them the option to proceed under subsection 4.
What other subsection would they proceed under, if not 4?
They don't really specifically explain that in Joshua. They just, the argument is, or I guess the holding is, that the permissive language says that, yes, you are able to proceed as if a reasonable cause determination was made, and thus the 1-year statute of limitations applies. But if you don't, the 4-year statute of limitations applies, and you have the option to choose either, which essentially just gives us the blanket 4-year statute of limitations. I was not a Supreme Court justice. I did not draft that language, but that is what it says.
When does the 4-year statute start to run?
The day 181.
Based on what? Based on
Just based
Joshua?
on, I would say, just based on the application I've seen across the.
So
But
in other
even-
words, just making it up
Even
again
if we
as
were to
opposed
just,
to looking at the
well,
statute.
unfortunately, given that the legislature didn't give us any clear direction, we are kind
But they
of.
have. That's when both sides of, like, criticize the legislature for not being clear. And I feel like, well, it doesn't really matter how I feel. The legislature has put text in and has specified how these things are supposed to happen. So you have 4 that provides that typically it accrues when the commission does something. It determines that you have a right to sue, or that there's probable cause or whatever. Then you have sub 8 now. You have 8B in particular. Well, you have 8 that says, okay, well, if the commission, if there is no agency action, basically, you can proceed, if you choose, I guess, under sub 4.
Right.
And then now there's 8B that says, provides the agency action that must happen. It says the agency must notify you of this failure to do something, I guess. Why can't that be fairly read to be your accrual period?
Because-
That it accrues when the agency does something,
Because
which is
the-
what 4 says as well.
Because the agency didn't do anything. That's the issue. That's this particular
Which means your
narrative.
action hasn't accrued yet.
Well, then that's going to get into what my colleague over here was saying, was that these actions could go on indefinitely. And
Well, they
we would-
wouldn't if you seek mandamus against the agency to make them do their job.
And now we're asking the employees to take steps that are not provided for in the statutory scheme and essentially take some course of action that would be contradictory to the liberal construction of that statute and essentially do the agency's job for them, which we would submit is not the burden of the employee.
And thank you, councilors, for your respective oral arguments this morning. This concludes our oral argument for this morning. We are adjourned.
All rise.